SJC-11961, Isabel Kain and others, v. Massachusetts Department of Environmental Protection.
Good morning, Ms. Rushlow. When you're ready, you may begin.
Good morning. I'm Jennifer Rushlow on behalf of the plaintiff appellants. The essence of this case is that the Department of Environmental Protection failed to act on a statutory mandate to promulgate regulations. In 2008, the legislature enacted the Global Warming Solutions Act as the Commonwealth's primary response to climate change. In Section 3D, the Department of Environmental Protection was required to promulgate regulations establishing declining annual aggregate emissions limits to be promulgated by January 1st, 2012 and take effect by January 1st, 2013.
Can I interrupt you? I'm trying to figure out the scope of your argument. Mm-hmm. One is that there were no regulations establishing the declining levels of aggregate emissions. But is it your view that 3D also includes that those regulations would have penalties for failing to do so in the various sources? Or I'm just trying to figure out what the what you're saying with respect to how broad these regulations are in terms of they set limits, but then how do they enforce them? It's really on the enforcement part. Are you saying that they also need to enforce them and have penalties, or is that part of 3D or something else?
Section 3D is silent on whether penalties need be applied to violations. There is a separate provision of the Global Warming Solutions Act that provides that the Department of Environmental Protection may assess fines. However, that has not been part of our argument for what Section 3D requires.
But you say legally enforceable maximum levels of greenhouse gases. That's what you want DEP to do, to establish legally enforceable. And I'm trying to figure out what they are to do if they do establish that in 2017, power plants should only emit so many tons of CO2, and what happens if they go above that? What kind of enforcement are you talking about?
Sure. We certainly do claim that Section 3D requires hard limits, and in the event that a party were to violate those limits, DEP certainly does have the power under the Global Warming Solutions Act to assess
and where does
a fine.
That come from? Where's that power?
That provision is included in, I can identify that provision for you. Sorry, just take a moment. It's in Section 7D that DEP has the ability to impose civil penalties for violations.
Okay, but you want aggregate limits. I mean, you want it for cars, you want it for power plants. It's one thing to say a particular entity has violated its limitation, but you're referring to aggregate limits over a whole set of sources.
We interpret aggregate to mean the total tons of carbon dioxide emissions collectively emitted by a group of sources. We're not talking about the aggregate emissions of the entire economy need to be addressed in one set of regulations, and we readily admit that DEP has discretion in determining what group of sources would be.
Okay, so let's imagine natural gas power plants. Okay, let's assume you've got some good natural gas power plants, some not so good, but the aggregate exceeds the limit set for 2017. What do you say they're supposed to do?
DEP would certainly have the ability to assess a fine in that situation
Against
if
whom?
a particular, against the source that had violated a mass-based emissions limit in Section 3D regulations.
But they all would have violated it if it's an aggregate limit. Are you saying they have to do it source by source? They'd have to go to each particular power plant?
There's a number of different ways in which an individual source's responsibilities under a mass-based regulation could be determined. For example, one could look at the Regional Greenhouse Gas Initiative as an example of how different sources' responsibilities are addressed. That's through a market-based mechanism. You can also look at examples such as the Total Maximum Daily Load program and the Clean Water Act example, where individual sources' responsibilities are determined through a permit. And the sum of all of their what they're permitted to pollute adds up to the total maximum daily load, which is the total mass that that water body can accommodate in terms of total pollution. A similar situation might be appropriate in these circumstances.
My concern, though, is this is a huge deal. I mean, this is a enormous degree of regulation that the state's going to be imposing in this area, and you're saying that the state did that simply by enacting on 3D, which says the department shall promulgate regulations establishing a desired level of declining annual aggregate emission limits for sources or categories of sources that emit greenhouse gas emissions. And you're saying that by doing that, they have triggered this extraordinary enforcement obligation for a violation of those limits?
That is what Section 3D requires. However, DEP has a great deal of discretion in determining what sources it's going to regulate and the breadth of that regulation.
Are the
So
sources
It
are the
doesn't have
ones?
to regulate, it doesn't have to set these declining levels for all sources or all categories.
That's right, I don't think Section 3D requires that.
Well, if it's, then how are you reading the total emissions?
Aggregate emissions?
Yeah, aggregate emissions.
Aggregate emissions refers to the sources that are going to be regulated by a particular set of regulations.
So are the sources that are going to be regulated those that are part of what gets covered in Section 2?
So the question is how, or as I hear it, the question is how,
Doing very well, but yes,
Oh, no.
probably, no, go ahead.
how does DEP decide what sources it's responsible for regulating? Certainly.
I mean, because I thought 2 had some, the actual monitoring and was defining which sources had to report and which sources they would encourage to report but didn't have to report, right?
Absolutely.
So I was thinking that those were connected, that those that had to report are the ones that are dealt with in 3, but is that not so?
Well, there are a number of responsibilities for different agencies under the Global Warming Solutions Act, and I don't know that Section 2 directly informs which sources DEP has to issue regulations for. But the question here really is, DEP hasn't issued any regulations that satisfy Section 3D. We might be in a different position of needing to consider how many sources they need to regulate, had they regulated any, but we're really starting from 0 here.
Can I ask you one more question?
Yeah.
One way, I guess, I thought of looking at 3D was it was given, in particular, that it terminates in 2020, correct? Mm-hmm. That it really was, at least one purpose, was to keep to set those limits and then have a way of measuring how we were doing getting from 2008 or whatever to 2020, where we were supposed to be at 25%, and then figuring out what you're going to do about that. But
Absolutely.
but that would be all of them, wouldn't it? Wouldn't you need to have limits for all of the sources of GHG?
Well, the Global Warming Solutions Act has, there are a number of different activities that are going to be taken to reduce greenhouse gas emissions under the Global Warming Solutions Act. It's not our position that DEP is responsible for accomplishing all of that under the Section 3D regulations, but they are responsible for issuing regulations that satisfy Section 3D, and that's where we say that they've fallen down. This case is really a failure to act case. We brought this case because DEP never issued any regulations under Section 3D. The affirmative defense that has been brought forward is that 3 specific regulations satisfy Section 3D. Our position on those regulations is that while they're valid in their own right, they do not satisfy Section 3D specifically. The position that's been articulated in this case by the Attorney General that those regulations satisfy Section 3D is not a position that was taken by the agency during the rulemaking process. And in fact, there was...
So you're saying because the agency didn't say, in order to satisfy 3D, we're doing X, Y, and Z, and because they didn't say that, The fact that they did something that might satisfy parts of 3D doesn't count?
What we're saying is it's very significant that the agency didn't cite Section 3D for authority from an Administrative Procedure Act perspective. It's not just a technicality. It means if DEP meant for these regulations to be the ones that satisfy Section 3D, they were required to give the public the opportunity for notice and comment on the specific issue of Section 3D compliance.
They were on the specific issue of Section 3D.
To create a record that would illuminate that issue for this court, to enable this court to make a determination as to whether those 3 regulations satisfy Section 3D. That administrative process.
I'm sorry, in the promulgation of the, in the promulgation of the regulations that DEP points to, was there a public announcement? Was there input? Was there ability for people to comment?
There was a notice and comment process for each
Okay.
of these regulations. They cited different statutory authority. There's no indication to look at these regulations on their face as they were issued to the public or any of the documents that were issued to the public along with them that the DEP was thinking of Section 3D when they put out these regulations. There's no way the public could have known
So
that that
even
was
if
the
they
intention.
satisfy 3D, the very fact that people didn't realize that maybe that's what these would satisfy, that that's a regulatory problem?
It's a procedural problem and speaks to an additional reason as to why these regulations can't satisfy Section 3D. We can't predict what the final outcome might have been of a proper notice and comment rulemaking process in this case. And now, it really speaks to the issue of agency deference, actually. There isn't an administrative record on these regulations on which this court can defer as to whether these regulations satisfy Section 3D. And where an agency fails to act on a statutory mandate, there's no agency deference. And where an agency takes a position that's specifically developed for litigation, which is in the nature of a post hoc rationalization, rather than the result of the agency's official exercise of its rulemaking authority, there is not
Do you
deference.
dispute that these regulations that the agency points to relate to the purposes of 3D? Are you saying that they're totally irrelevant to the agency's responsibilities under 3D?
We like these regulations very much from a greenhouse gas emissions perspective. We're not saying they're bad regulations. We're not saying they're unrelated to the Global Warming Solutions Act as a whole, but we do not say that they satisfy Section 3D. What Section 3D requires is something very specific. It requires new regulations that place an annually declining cap on collective emissions of a regulated group of sources. These regulations don't do that.
So you parse the statute in a way that is a little unusual. You assign a meaning to just about every word in the statute. Where does that come from? I mean, I looked at your brief. I mean, it's just pages and pages and pages, and there's not a citation to anything. It's just the plaintiff's thought about what these words mean. Where does that come from?
We believe it's a plain reading of the words of the statute. We believe it's very clear on its face and that it's not ambiguous just looking at the words plain meaning.
Okay.
So so what you would say is, yes, they're related to the plan that the secretary was required and did promulgate, but you would say there's discretion in that language in terms of DEP has discretion to not take on the entire universe of greenhouse gas sources, but to say, presumably in consultation with the secretary, well, we're going to focus on whatever, power plants or buildings or anyway, something. And then that's what they would do and measure it, and then you'd use 7D. They could enforce it with a lot of discretion. But that's how you see this working, is that?
Absolutely. It has to be multiple regulations. It has to address groups of sources, but the agency was given great discretion in determining what those sources are.
Now,
We
these
don't dispute
regulations are designed to blow up in 2020,
That's right.
which means that they are intended to meet this 2020 limit.
That's right. The purpose of Section 3D is in service of reaching that 2020 statewide emissions limit as set out in
Now, when you
Section
say that they're not required to pursue all sources, I assume you believe that 3D requires them to do it for the primary sources of greenhouse gases,
We do.
not just pick and choose a couple random sources and say, we've done our job.
It's sort
And
of
the- and the-
what's reasonably possible within the whole universe.
Well, the agency has to have a rational basis for determining what sources it will focus on in those regulations, and that has to be set out in an administrative record, which this court can review to determine whether they satisfy Section 3D. With my last remaining 30 seconds, I would just note that our argument isn't simply procedural on why these regulations don't satisfy 3D, it's also substantive. As I said, these regulations aren't really properly before this court because they were not put to the public as Section 3D regulations. But putting that aside for a moment, none of them satisfy Section 3D because they don't limit aggregate emissions in Massachusetts. For the sulfur hexafluoride regulations and the low emission vehicle regulations, they use a rate structure which can't limit aggregate emissions. And for the Regional Greenhouse Gas Initiative, they don't limit aggregate emissions in Massachusetts specifically, which is the entire aim of the statute, and therefore cannot satisfy
Okay,
Section 3D.
but the statute says establish limits, doesn't say limit.
Actually, just establish levels, desired levels.
Establish desired levels. So you're interpreting that to mean establish limits or
Level
establish?
of annual aggregate emission limits.
That's right.
Okay, thank you.
Thank you.
Good morning, Your Honors. Joanne Shotwell-Kaplan for the Appellee Department of Environmental Protection. As you've heard, the sole issue before you today is whether at least one of 3 sets of regulations that the department did issue after enactment of the Global Warming Solutions Act satisfies the terms of Section 3D of that statute.
Which was
And-
enacted after?
I'm sorry?
Was enacted
They
after?
all 3 that were enacted
Some
after.
were pre-existing.
No, the 2 of them amended
They were
pre-existing programs, the Lev amendments and the Reggie amendments. The
Were amended, was it pursuant to 3D?
3D was not cited. There is no record created by the appellants with respect to regulatory intent, and of course, regulatory intent is irrelevant. What matters is whether the regulations do in fact satisfy Section 3D. Their speculation that these were not intended to satisfy Section 3D is incorrect. Section 21N generally, the GWSA generally, was cited in the course of the public rulemaking process. So certainly people were on notice. And this is a pure legal question, a pure question of statutory construction. There is no record to create, nor any need to create a record on a pure question of statutory
So
interpretation.
if I look at your regulations, what is the desired level of declining annual aggregate emission limits for regional power plants in 2016?
We actually set a regional, and this is the only issue that remains for your resolution about the Reggie amendments, given things that are said in the reply brief. The only issue with respect to the Reggie amendments, whether they satisfy it, is their regional nature. There is a regional cap on all emissions from the plants that are subject to this that must decline by 2.5% per year. Now, with respect to enforcement, it's a
Is it
market-based.
an aggregate cap, or is it for each power plant they must reduce it by 2.5%?
It is an aggregate cap that applies to the totality of the regulated
The
sources.
cap that they can purchase power from somebody else, right?
For the Massachusetts cap, yes. The Massachusetts cap is reducing by 2.5% the Massachusetts allocation of a regional allocation. And the regional cap is similarly reflected in the state's caps of the other participating states. So you have all of these state caps, which are an allocation of the total regional cap, declining each year by 2.5%. The only thing that they object to about the Reggie program now, they otherwise concede that it does qualify as a Section 3D regulation, is the fact that it's a regional program. It does not guarantee that the emission reductions associated with the declining emission limits occur in Massachusetts. And there is nothing in the GWSA or Section 3D that requires that emission reductions associated with declining emission limits occur in the state. And it's completely inconsistent with the science of climate change to think that they need to. Climate change is not even just a regional issue, it's a global phenomenon. And emission reductions anywhere contribute to the solution everywhere. And the
Are you
GWSA actually requires a regional approach, I'm sorry, Your Honor, with respect to this sector of the economy. It says in Section 3C that we must take a regional approach, we must take RGGI into account. We then rely on Section 3D and satisfy it by having the declining emission limits. So we treat the two provisions as harmonious, and we simultaneously satisfy them both.
And how do we satisfy D at all with the LEV or the other one that I'm forgetting?
Well, the issues here have actually been significantly narrowed. I did want to say this with respect to their reply brief and some of the comments made today. For one thing, they now concede that the department does have the discretion both to decide what sources or categories of sources it will address with their Section 3D regulations and to comprise the categories. It also now agrees that with respect to a rate, that a rate is okay, is a limit, in their view, as long as it is applied to a finite number of sources. And our SF6 regulations therefore do precisely what they say they want.
Well, but how do any of these relate to the Secretary's plan and getting from 2008 to 2020 to reduce overall emissions within the Commonwealth by 25%?
They all do that very significantly.
How are you
because,
measuring annual declining?
as we indicate, and we provide some figures for you on this in the brief, Your Honor, these affect extremely significant emission reductions between now and 2020 from the power sector, from the automobile sector, and they reduce...
Have you done regulations that establish the desired level of annual aggregate emission limits?
We absolutely have, and they agree that we've done that with RGGI, with the sole exception of this regional question.
That's not a sole, but okay. But how about the other two?
And what I'm suggesting, Your Honor, is that they now effectively agree that we've done it with the SF6 regulations. If I can explain just quickly, the reason is because they now say a rate's okay as long as you apply it to a finite number of sources. The reason being because you are then capping the total emissions from that category of sources, which is the way they want us to interpret limit generally. Well, with our SF6 regulations, we do precisely that. We devise a category of sources, which they say is within our discretion, that includes all GIS equipment, all existing GIS equipment of all significant GIS sources in the Commonwealth. That's a finite number of sources. And we apply the rate to that, and therefore, in that way, we in fact do exactly what they say they want.
Why? I just don't get the math on that. If you have all sources in 2015, and then there's a huge influx of GIS equipment in 2016, how does this work?
The regulation doesn't apply to new sources. The declining limits, the category that we have devised, is of existing sources, and that is a finite number.
How does that go to aggregate emissions for the Commonwealth for the year?
It's aggregate emissions. Aggregate simply means total emissions. It's modified by annual. It in turn modifies emission limits for sources or categories of sources. It simply means we have to limit, which does not mean cap. We have to limit, in this case we do, the total emissions per year, the total emissions over the course of the year from the category of sources.
The phrase aggregate emission limits is part of what the Secretary has to do, right?
Well, the Secretary takes on statewide emission limits, Your Honor, which is a little different.
Isn't it?
That's the totality of all emissions from all sources,
These are not
residences.
unrelated, are they?
Oh, they're not unrelated, but Section
They're
3D
very
is...
related, aren't
Well,
they?
Section 3D is but one of many tools available to the state to reach the 2020 limit. It does not have the...
Not being reached, apparently.
Well, actually, Your Honor, that issue is not before you, but we do strongly disagree with that suggestion.
Is that a
We are-
misquote of the Secretary from November?
That is a misquote. What he said to the legislature was, and you can check it with the site they provide, is if we do nothing more between now and 2020, we will not reach the limit. He did not say there's no chance we will meet it. We are 100% committed to meeting it. We have a track record, I suggest, that should confirm for anyone that we have the commitment and the ability to meet it. We had reduced emissions by 24% by 2012. There was an uptick in 2013 due to a very cold winter, but the overall trend is decidedly and dramatically downward. We have earned our reputation as a leader, a national leader on climate change, and we fully intend to continue to earn it.
Have you published the limits for 2015? As to whether, I mean, do we have limits for 2015 to determine whether or not we are on target to reach the 2020 because we have or have not reached the 2015 limits?
Yes, Your Honor, we
What is the
continually track.
2015 limit? What's the aggregate emission limits for 2015?
Well, it's broken down by sector in terms of
For
our
those-
Section
for those-
3D
those-
regulations.
Those three sectors.
Yes,
You
Your Honor.
mentioned the low-emission vehicles.
Yep.
Does that, by the way, incorporate the fact that this is a banner year for Detroit for selling not only vehicles, but larger vehicles with the reduction in the price of gas? Does that incorporate anything to do with the increasing sale of cars and of SUVs?
I'm not sure I'm understanding the question,
One of the
Your Honor.
concerns is that you may reduce the low emission per car, but if the total number of cars and if the nature of cars change to be moving towards trucks and SUVs, you're going to be generating a higher level of emissions. Does this incorporate changes in the number and type of vehicles?
Well, it encompasses a certain category, so-called light-duty vehicles, which includes passenger cars as well as some SUVs and light-duty trucks, Your Honor. We don't get to devise this particular category. In the vehicle arena, we are preempted from doing much completely on our own. So we have to accept the categories that California accepts and sets. What we've done in the, and we do
but it's a
not, because
rate.
we don't control the number of vehicles, because we don't
Well, you do
control
control the ability to tax the sale of vehicles, do you not?
DEP, Your Honor? No.
No, the state.
Well, I don't know, Your Honor. I'm not
The
talking about.
legislature couldn't impose a sales tax on cars, which may depend upon the amount of greenhouse gases? Was that not something that the legislature has the power to do?
Well, I'm not suggesting that it doesn't, Your Honor, but I don't speak for the legislature.
I
speak
understand,
for
but I
the
mean, but in
department.
terms of if you were to say, listen, we're well below where we're supposed to be in low emissions because the number of vehicles and the nature of vehicles is changing in Massachusetts, and we need to get people to be purchasing smaller and more efficient cars, and therefore we should be taxing the sale of SUVs and small trucks in a manner that will incentivize people to purchase that. That is something DEP could do, could it not?
To tax them? No, Your Honor, it couldn't.
Could invite the legislature to do that as a legislative formula in order for you to meet your limits.
Well, we have a plan to meet the limits, Your Honor. It's got a portfolio of policies. It does not depend on a single additional Section 3D regulation.
That plan.
The
Where-
legislature
excuse
has
me,
its
where
own
do we
views.
find that plan? Where do we find, you've said that 3D is only one of many tools.
Mm-hmm.
How are we to find out what the other tools are that you're using and how, and is there a source to look at?
There most certainly is. It's cited in the materials. It's called the Clean Energy Climate Plan, and it has a portfolio of policies that's quite extensive.
Secretary's plan, or is this?
Yes.
It's the Secretary's plan, that's correct. And then DEP helps to implement aspects of the Secretary's plan.
Are there aspects other than the regulations that the DEP?
Oh, absolutely, absolutely. There's energy efficiency, there's renewable energy. I mean, speaking of what the administration believes is the next move for the legislature, Your Honor, that's what Secretary Beaton was testifying about. The administration is urging the legislature to enact hydropower legislation. So it is multifaceted, and there are many ways in which we can and we will reach the 2020 emissions limit. Section 3D regulations are the least of it. But the question before you is, have we satisfied Section 3D? With respect to the SF6 regulations, again, they have now effectively agreed that we do satisfy Section 3D. If you agree with us about the regional approach being no problem for the RGGI amendments, then they have agreed with us that the RGGI amendments satisfy them. If you agree with us, and they're now conceding that the department has discretion with respect to what sources or categories of sources it regulates under Section 3D, then you need not reach a single other question. You need not reach the Lev amendments, and you need not reach our assertion that Section 3D doesn't even require actual emission limits, but rather emission reduction targets, a desired level of emission limits, if you will. But with respect to the Lev amendments, that's where you would have to get into the debate about the meaning of the word limit, the debate about the meaning of the word aggregate. We think that it is very clear that limit is a broad concept. It is used, it's equated with limitation in Section 7D, which is the enforcement provision of the statute, because that provision does not use the word limit, and surely no one is taking the position that whatever we do by virtue of Section 3D is unenforceable. And so you have to equate it with the word limitation for it to be enforceable.
I'm just looking at this language. The department shall promulgate regulations establishing a desired level of declining annual aggregate emission limits for sources. Okay. The plaintiffs concede that it's not every source, that you have some discretion. But let's just take any source. It seems to me that language says there should be a regulation that says in 2015, the desired annual level of declining aggregate emissions is X. Where is that?
Well, for sources, this is source-specific, so whether we take on multiple sources individually or we take them on as a category, it's not the statewide emissions.
I'm taking a source. Where is a regulation that says the annual aggregate for 2015, the desired level of declining annual aggregate emission limits for this source or group of sources is X?
Well, Your Honor, if we worded the regulation exactly that way, we would be setting emission reduction targets, which is actually what we think Section 3 is all we think Section 3D requires.
Haven't done that, though, have you?
No, but we've done more than that. We've set actual emission limits.
But you haven't done what it says.
Well, yes, we have, because you can find in our regulations the desired level of emission reductions for the sources on which we set limits.
For each year?
Yes, for each year, because they
Identified year
decline
by year.
annually. It's a mathematics exercise to take what we say in terms of the declining limit and calculate what the emission reductions are, and we do that math. I mean, to answer a question I never completely answered, we do it periodically. We report on the inventory of emissions to date and where we stand vis-a-vis
I think it would
the
be
emission
helpful
limits.
to us if you could send us a letter identifying for each year what you claim to be the desired level of declining annual aggregate emission limits, so that we can, you say that they exist, help us to find them.
Well, Your Honor, if I may say, there is a report coming out, I believe as early as next Monday, sometime next week, which is the update to the Clean Energy Climate Plan. And the whole role of that is to evaluate where we
I leave it to you
stand.
as to what the letter says, but you say that they exist, help us to find them.
Okay, do the math, in other words.
But
Regulations,
yeah, is it in the regulations? Is each year's declining amount set forth in the regulations, year by year?
Each year's declining limit, which is what's required, that's what has to decline is the limit. Each year's declining emission limit is absolutely set forth in the regulations.
Aggregate
And
emission
they
limit?
are aggregate limits.
Not car by car, aggregate.
No, they are aggregate. They are aggregate. They are addressing the total emissions from the regulated sources or the regulated category of sources. They recognize that. They object to the fact that it's a rate unless the number of sources is finite.
A rate isn't a limit. I mean, because just to take the cars, you could have an influx of SUVs. Why is a rate going to help with the limit?
It doesn't mean it's not a limit, Your Honor. A limit is just something that limits. And it does limit. In fact, rates dramatically reduce emissions, dramatically, and they do in our regulations, and they will. A rate reduces emissions. A rate is a limitation on what...
It can reduce emissions. It does not necessarily reduce emissions.
Well, in our economy, it does, because we're not a major growth economy. We have a relatively stable number of sources, so as a matter of fact, it does, as a practical matter. But limit does not mean absolute, never to be exceeded cap, which is how they want you to read the word. And we're beyond this issue. With respect to the SF6 regulations, this is never an issue with respect to the RGGI amendments because they don't use a rate. So you only need to reach the rate issue if you get to the LEV amendments, which I suggest you needn't do. But a limit need not be a cap. They rely on definitions that don't apply and can't apply to the department's regulations in order to try and get it to be a volumetric cap.
I'm looking at the definition of greenhouse gas emissions limit in Section 1. Is everything you say that can be a rate?
That definition is applying to the secretaries. It expressly applies to the
Just
secretary's
suggesting to you
limits.
that the words gas emissions limit and annual aggregate emissions limit have something to do with each other.
Well, sure they do, because the
Seems like they're the
source-specific
same.
regulations, of course, have something to do with achieving overall statewide emission reductions. But the question is, what's the meaning of limit? And it's only in the context
Are you
of
saying
the...
its limit is differently defined in Section 1 and Section 3D?
Oh, absolutely it is, Your Honor, because if you read the definitions in Section 1, they specifically reference authorizations to emit up to levels specified by the Secretary. Well, the Secretary doesn't specify any levels for the years between now and 2020. The first Secretary specified level is in 2020.
That's right, and that's what DEP is supposed to do.
No, but it's supposed to do this annually, Your Honor, cover the period between now and 2020. In fact, the regulations go out of existence under Section 3D.
Appreciate that fact.
Right.
That's
So
right.
it can't mean the same thing. There is no authorization from the Secretary for covering emissions in the years leading up to 2020. It must mean something different. And it's just using the word limit. It just means we have to limit emissions from what they could otherwise be in the absence of that measure. And we do that. Rates do that, and they do it very effectively. There's a long history of using rates for limits. There's a long history of regulation at the state and federal level that equates limit with the word limitation and specifically allows rates as emission limits.
One more question. What percentage of greenhouse gases in Massachusetts are covered by the low-emission vehicle program, the sulfur hexafluoride gas, and the power plants within the Regional Greenhouse Gas Initiative?
I can't answer that question off the top of my head. It would be reflected in the Clean Energy Climate Plan. I can tell you that the power sector, the building sector, and the transportation sector are all considered very significant sectors.
But do you have, is it more than half? I mean, are we covering only 30% of the greenhouse gases, or are we covering 90% of the greenhouse
I
gases?
can't answer that question. I can say it's a substantial proportion.
Isn't that important? I mean, if it's only 30%, are you satisfying 3D if you've covered only 30% of the sources?
Yes, we would be, Your Honor. If Section 3D
how low
is
can you go? Can you go to 5%?
Section 3D is one of many tools.
Okay,
It is-
answer my question.
I don't know
Is there any, I mean, are you saying that basically you can choose any three and that satisfies 3D regardless of what percentage of the greenhouse gas it covers?
I think it would satisfy the letter of 3D. Would the legislature be happy with the department? Quite possibly not. But it left to the department's discretion, for very good reasons, the decision about what sources or categories of sources to address in this particular way. I mean, we don't have to have declining rates over time. We can go straight to the bottom line by virtue of other authority and effect greater reductions immediately, rather than spacing them out over the time. We do that with all new sources of SF6 in the Commonwealth.
When you write your letter, could you give us that information as to what percentage of the greenhouse gases are covered by the 3 regulations?
I'll be happy to, Your Honor. So if I remember my homework, I'm to submit a letter that answers that question, and more generally, what was your
Letter that
question, Your
says
Honor?
you say that the regulations establish the aggregate emission limits for these sources for each year. Tell us which particular regulation that is so we can look and find what you say is satisfying your obligation under 3D.
The aggregate emission limits we've already given you. Did you mean what
No, I mean,
emission
we'd
reductions
like
we
to know.
accomplish?
We'd like to. I mean, part of the issue here is. Well, let me ask you: Do you disagree that part of the legislative purpose for this was so that the legislature could learn from DEP how we are doing in terms of meeting our 2020 goal? That we can learn each year whether we're getting there or whether we're not getting there.
I don't completely agree with that, Your Honor. I think that the legislature was looking for the state to have targets in order to help it meet the 2020 emission limit, and that the state would have to be doing that calculation in order for the targets to be meaningful. But it's the 2020, it's the CECP update that provides the information you're talking about. The information the legislature wants is from the secretary periodically to tell the legislature where we stand with respect to the 2020 limit, and then thereafter the other limits.
But requires it to be an annual aggregate emission limit, so it's for each year.
The limit is for each year, and we have that.
Okay, and if you would identify us for each year, where in the regulation it establishes that limit,
That
so we
limit?
can see.
Well, we've
when
already
you
done
say
that
it's-
in the
When you
brief.
say it's right there in the regs, and you can look and see what the limit is for each of these three categories.
Yes.
For each year, help us to see what you mean by that, so we can evaluate whether or not we agree that there is a limit which is articulable and in satisfaction of 3D.
I'd be happy to do that, Your Honor.
Is that in keeping with my
I
colleagues?
just
Okay.
actually
Thank
have
you.
a request of the plaintiffs. That is, Ms. Kaplan has indicated that you have conceded that, no, it's a 16L letter, sorry. If you might address the claim that your reply brief has conceded that these regulations, or two of the three, satisfy 3D.
Okay, thank you.
Your Honor, if I may say, I didn't quite say that. I said that if you, on the Reggie front, if you dismissed their concern about the
No,
regional...
that's the three, isn't it? Oh, okay, 1.5 of the three.
Yeah, and on SF6, that they have...
Okay, thank you.